Hi everyone. Good morning. I apologize for being 4 5 minutes late. Am I audible?
Yes, ma'am. You're
Okay.
audible.
Cool. All right. So there are 52 people. Now I would have taken introduction one by one. Good morning, Rajiv. I would have taken introduction one by one and gotten to know you guys. But just for like a brief overview before we begin, how many of you are have a debating background? Just type in yes in the chat box and I'll get to know. How many of you have a debating background? That's all I want to know. Okay, so we have Abir who has it and Aditya also. Um, Anyone else? Manvi, Adnan. Okay, so we have four among us. All right. So the reason why I ask you is because if you have a debating background, it gets a bit easier in being articulate regarding your responses, regarding your certain extempore responses. Uh, that's the major inspiration behind asking that. Regardless, if even if you don't have a debating background, that doesn't really hamper you because this is a skill that you have to learn, and even debaters have to mold themselves into being advocates because advocacy is a completely different skill from a debating thing, a debater stuff. All right, so. Someone will also have to brief me regarding what the mood proposition is for this FIM because I need a basic idea, a basic overview. Moreover, I also want to test out how well apprised are you of your facts and how well you can shorten your facts. If anyone can just unmute themselves and then brief me on the facts of the problem.
Ma'am, ma'am, in moot cases we have some case with facts. The fact is which we have to decide what is case and
Okay,
what is
Sonali,
the material.
Sonali, I'm going to stop you right there. I'm talking about the FIM thing. Is anyone preparing for the FIM? For the freshers induction mood?
Yes, ma'am. I am preparing for it.
Yeah, okay. So whoever is preparing for FIM, one of you guys can just be brave and can volunteer information regarding the facts of that particular problem.
I would like to do it, ma'am.
Sure, go ahead, Tushar.
Do we?
Okay, ma'am. So, for the facts of the case or the statement of facts in this case are there are two persons, Miss Diya Nayak and Mr. Dani Sarkar. They both study at the same college, and they both have mutual understanding between them, and their classmates infer from the relationship that they would be they would be marrying after the college. So after completing their graduations, Mr. Danish got job, whereas Miss Diya wants to study more further. Because of the insistence of her father, she decides to marry Mr. Danish with his father's consent. So marriage was formalized between the parties, and the father of Miss Diya spent around 50 lakh as gifts on his marriage. After marriage, what happens is Miss Dia went to Sassural, and within 3 days of the marriage, exactly on the marriage happened on 25th December, and on 28th December, the first incident happened at matrimonial residence, in which the father-in-law of Miss Dia and her mother-in-law humiliated her by passing some sarcastic remarks of the gifts given by his parents. Like they said that the gifts were of inferior and worst quality. So Miss Dia was very sad with that, and she kept on crying the whole night. And her husband next day told her that she should not respond to her parents. So next week on date January 1, 2020, what happens is that they go to Tahiti for their honeymoon. However, the marriage still doesn't consummate on account of Miss Dia's vow of sexual obsession until she secured a seat at London School of Economics. That was her dream school where she wants to study further. On reaching back of 15th century, they reach back and resume their daily lives. What happens is that on January 2020, a series of events happened. First of all, at 9 a.m., Ms. Dia expressed his desire to go her parents and live there for a month. By that time, Mr. Danish's father and mother came to know about that they haven't consummated the relationship yet, and they scold Miss Dia that you have spoiled the life of my son. In Bengali, they said some words which mean that this will not happen. What kind of person you are? You have spoiled the life of my son, and now what are you planning for? At this, Dia cried in front of her husband. To this, his father-in-law said, if you want to go, then please go and never come back.
I see. All right. I think that will be it, Tushar. Thank you for that narration. So the thing why I asked regarding the facts is, it's quite simple, because what happens is when you start the oral arguments, the first thing that you're supposed to ask is whether you can address the bench collectively and individually as your lordship or as your ladyship, whatever you prefer. Then the second thing that you're supposed to ask, if you're the first party going ahead, that is like if you're the petitioner or the appellant, then you're supposed to ask the bench whether the bench is apprised, whether your lordship is apprised of the facts. And if they are apprised of the facts, then you can go straight away to the arguments. If they're not apprised of the facts, then they will ask you, can you please brief us the facts, right? Why they ask you regarding that is, why they ask you to provide a brief of the facts is that they want to understand if you have understood what exactly is the cause of action. Okay, so a cause of action basically is that it's an event or a series of events that triggers a legal that initiates a legal proceeding. So, for example, in this particular case, as we have seen, the cruelty being inflicted on her regarding the dowry stuff and regarding certain issue of consummation. Is the cause of action, has led to the cause of action, because she has cried, she has been humiliated, that comes under the wide ambit of cruelty. So naturally, that will be the cause of action in this particular case. And from then on, we'll start our arguments, or we will start the research after we had detected the cause of action. So the thing is that I'm not going to go through the legal arguments that you're supposed to frame for this particular FIM, because that is something that you have to do, and that is something on the basis of which your skill will be tested. Moreover, if I tell you the exact legal arguments in this particular problem, then the 85 people who are present over there and the 20 potential people who are supposed to go for the FIM, or like however many people are supposed to go for the FIM, they might end up reiterating the arguments that I have told you guys about. And that will end up creating more of a copy paste approach to your arguments, which I don't really want to do right now. Okay, so Devi, I appreciate the fact that you have just shared your screen, but can you just not share your screen with us for a second? And that will be great. All right, thank you. You don't really have to show me my face either, so that will be just fine if you can just stop the sharing thing altogether. Thank you, Devi. All right. So what I'll do instead is that I'll take you through a taxation moot problem that I had the privilege of dealing with recently. And I'll show you how I did my research. And from that, you can get inspired, you can get motivated to do your own research in that particular aspect. And I'll take you through how I detect a certain cause of action, a certain legal action, and how we initiate the proceedings and how we brief the facts also. And moreover, I hope that at the end of this meet, we end up getting a lot of mooters out of this, and this doesn't get succumb to this particular meet. Okay, now I'll just share my screen with the moot problem. Okay, and we don't really have to be this much silent. If you don't understand anything that I say, you can ask me to repeat it again. If you feel uncomfortable with me speaking in English, then I can repeat that particular sentence that you didn't understand in English in Hindi also. So do not treat this as like a unilateral lecture that I'm giving you guys. Let's keep it as more of an interaction. If you don't understand anything, do let me know right away, right then. And this is a very crucial thing that you guys need to understand, because I think this will end up as your foundation for getting inspired to go into mooting. So I'll just begin with the importance of mooting, and then we will just skip to the sharing of the screen and the whole thing regarding that. So the importance of mooting is quite simple. No matter if you're practicing it. Hi Arun, is that a question? Because I can't understand you. And if that's not a question, you can keep yourself on mute. So I think you can just, yeah.
Ma'am, please use a mixture of language like Hindi and Hindi both.
Okay, sure, I will. And also, if I go a
Yeah,
little
ma'am.
fast, do let me know about that, because I tend to go a little fast. Okay,
That's completely fine, ma'am. So
perfect, great. And you don't have to call me ma'am. I'm just your senior. You can call me Samriddhi. That's perfectly fine. All right, we are peers over here. That's completely understandable. Okay, now, so the mooting skill actually comes into effect even if you're in a litigation firm or if you're in pure litigation. Because it teaches you advocacy, right? It teaches you how to research, it teaches you how to frame your arguments, it teaches you writing. And from the drafting of the arguments, which relates to certain aspects of writing, and from research, how you find out certain cases and how you hunt down the cases, and from speaking skills, and from how to be confident and how to handle certain questions that you don't know the answer to, that really teaches you how to be more articulate with your arguments and how deep you have to have your knowledge of law. So, for example, you might have studied IPC, and you might have studied law. But in my freshest time, I actually did, in my FIM time, I actually did the problem on medical negligence and tort. So that taught me a lot about the intricacies of tort and the intricacies of medical negligence and how Boland's test is applicable. And you will be studying this Boland's test in your tort. And how defamation and what are the elements of defamation, what are the differences between slander and libel, and how do you differentiate between those two, and can an unconditional apology be sufficient? This really comes into effect, and this really comes into help when you actually go out for practice, because even if you go for internships, like I have recently, then I had certain problems on criminal law, and I had certain moot problems on tax law. So when I went to my internships, it really helped me to inculcate that knowledge and to apply that knowledge. So I did not need to start from scratch regarding bail. I did not need to revise my particulars, my fundamentals about bail, because I already had KK Luthra's research to fall back upon, and I'd already gone through that in quite detail. So that really helped me out. Now I'll just share my screen to show you the tax problem that I went through, and we can start deducting the. Let me know if you can see my screen, all right? I hope you can see my screen. I'll take your silence as a yes, I believe. And
yes, ma'am. It's
perfect. Great.
Yes,
All right. So in this particular case, we had the K.R. Ramamani Memorial National Taxation Moot problem, as you can see on my screen. And the tax problem was based upon Section 40 AIA and Section 201. I'll brief you about that. So Section 40 actually deals with deductions. And so when you have your income tax, when you file your income tax returns, then certain expenditures get deducted from you, right? So for example, if your liability to pay taxes, let's say 10 lakh rupees, and you had incurred expenditure in your business for...
Ma'am, could you just zoom in the photo a little bit, like the screen?
Sure. Can you see it now better?
Yeah, ma'am, much better.
Perfect. Good. So what happens is that, for example, if you're running a business and you have 10 lakh rupees of tax liabilities towards the state because of your turnover, because of your profits, and out of those 10 lakhs, you have incurred expenditure. Like, for example, you spent on painting your garage, or you spent 2 lakhs on getting furniture for your office and everything, then that's expenditure that can be deducted out of your tax liability. So tax liability gets reduced to 2 lakhs rupees. So Section 40 actually deals with what exactly gets deducted and what exactly does not can't get deducted. And then 201 deals with what exactly is an assessee in default. So this particular tax problem was actually in the form of an tribunal order that was given to us. All right. And when you read a taxation, when you read a moot problem itself, you will already see a pre-framed issue. Okay, like for example, in this particular case, this is the issue that they gave us, whether the tribunal order is perverse in law in holding that the second proviso of section 40 is curative and thus retrospective in its application. Now, I'll start with the very fundamentals, because I don't know if your teachers have taken you through those fundamentals or not, but I would really love to cover that. So the first thing is that when you write your issue in your memo, you do not write your issue as that whether the tribunal order, because for example, in this particular case, if I had to write it down and not use the colon in this particular case, then it will be which have been admitted by the Honorable High Court and fixed for the final hearing. That whether is not does not work, right? You just have to use for final hearing whether the thing. Right. My simple reason in highlighting that is because those are small little mistakes that show how that tend to reflect how amateur you are in mooting, and that gives the other team an edge. Because how in a professional mooting thing, not just a professional but the actual mooting, how it works is that memos are exchanged with the other team. So your memo will be sent to the other team, and the other team's memo will be sent to you. So through the memo, you'll be able to see the research and what has been done in that particular research, and how well they are researched, and what are the arguments exactly, and what all nitty-gritties have they gone into. So naturally, if you commit mistakes like this, if you commit faults like this, the other team will get to know that ye to bacche hain, inko to le sakte hain hum log. So yeah, we don't need to give them that first impression kind of a thing, right? Let's be intimidating as much as we can. So why that whether is not used? For the simple reason is that when you translate it, it gets translated into this particular sentence, right? So for example, आज का विषय है कि हम लोग इस बारे में डिस्कस करेंगे. So that की gets in is the translation of that whether. Okay, so that's like little things that I want to really point out. Okay, now this. Okay, yeah. And there we go. Can you see? I hope you can see. Okay, so this is like a tribunal order that you usually get, and we were given this tribunal order as like facts of in the format of a facts of the case. Now, how do you detect facts of the case? Okay, so when you are asked to brief regarding the facts of the case, the facts of this particular case would be that there was a company A who entered into a transaction with company B. And in this particular transaction, there was an amount, and this amount is in dispute because this amount was disallowed by the income tax department. But the assessee, company A, is contending that this particular amount is actually, it should have not been disallowed and should have been allowed as a deduction in the income tax returns. And they are claiming that they're not assessee in default, because any action can be taken against you when you are in wrong, right? If you are held liable for something, only then can proceeding be taken against you. So the whole title, the whole status of being an assessee in default was being contested in this particular case. So those are the facts of the case. You don't need to go into like what exactly happened and usne kya kaha, isne kya kaha, there was software company or not. You don't need to go into that. All you need to tell is that there was a company A, there was a company B. The other side is representing company A. We are the income tax department. They had this particular amount. This amount has been disallowed. So basically try to brief your facts into 2-3 sentences. This is just me reiterating what your teachers have told you, that when you are writing even in your exams, your facts should be just 2 to 3 sentences, not more than that, because facts do not decide the case. The ratio is decided. The ratio decides the case. The obiter dicta decides the case sometimes. So that is crucial. So that's why whenever anyone asks you to tell the facts of the case, you do not have to read the facts of the case. You can just tell the facts of the case in 2-3 sentences at most. How you do it is that you practice trying to say this fact of the case out loud. So in this particular case, naturally, the cause of the action is the disallowance that was done by the department, right? So the AO passed an order disallowing the entire payment. This is the cause of action, because this particular action then led to a case being initiated, right? And then these are the facts. So we were given more of a matter of fact situation, which is like कि इस side ने ये बोला है, उस side ने ये बोला है, बाकी अब आप लोग आगे frame करो, because this was an appeal case. So how you might have been given your FIM is that ये incident हुआ, फिर incident B हुआ, फिर incident C हुआ, फिर incident D हुआ. अब तुम decide करो तुम्हें side कौन सा लेना है और तुम्हें issue कौन सा frame करना है. They might not even have given you pre-framed issues. So naturally, how you do that is that you apply your legal acumen to that. And naturally, because you are freshers right now, so you might not have developed that legal acumen currently, and that needs a little getting used to. How you get used to that legal acumen is that you read the judgments and not Dukki. So try to take that a bit to heart and try to listen to your teachers. Read your case mats. Don't read the abridged versions, but read the cases that are given in the case mats. Look up those cases, find out the citations of those cases, look them up, read the whole judgment, find out what was discussed, why the judge decided the way he did, and how has that particular jurisprudence been established. Okay, so the single reason for the jurisprudence, why I'm talking about using the word jurisprudence does not mean what you're studying right now. Jurisprudence signifies a philosophy in a particular field of law. So, for example, in let's say criminal law, for bail purposes, the jurisprudence was established by Justice Krishna Iyer in Gudikantu Narasimhalu versus Public Prosecutor of Madras, where he said that a bail can be given when 3 conditions are fulfilled, right? So that was the jurisprudence. From then on, a philosophy of bail was established that bail is the rule and jail is the exception. Right, that particular phrase itself is established as jurisprudence further on. Now, after that, certain exceptions were framed and all and everything. So that's something that we get into. For example, in IPC, you might have studied Gurmeet Singh versus State of Punjab, right? Okay, you guys can say yes or no promptly. So in Gurmeet Singh, what happens is it's a rape case. So I believe you might have studied it by now. So in that particular case,
No,
there's this
ma'am,
particular.
not yet.
Okay, cool. Then you'll come across. And so Gurmeet Singh is a very interesting case, largely because there is a rape that has happened. There's an incident of rape that has happened with this school-going girl, and this girl is very afraid, and she tells her parents quite late. Naturally, because of the medical examination and all and everything, a lot of evidence gets disputed, and the Sessions Court judge, humiliates her. And then he says, and then he gives a judgment in favor of the accused, that accused should be acquitted. That gets appealed in High Court and then gets appealed in Supreme Court, and the Supreme Court says that no, the victim should be believed, right? So the whole notion of believing the victim and not the accused, because the victim is the one who's going through the hardship, has established a jurisprudence, and that jurisprudence also was then established after Tukaram versus State of Maharashtra. Have you studied Tukaram versus State of Maharashtra yet?
No.
Okay.
No,
perfect.
no, ma'am.
All right. So regardless, I'm not going to give you any spoilers regarding Tukaram because that's a very substantial case. So yeah. So that's exactly what jurisprudence is. And when you're doing your research, you will get to know a lot of landmark cases and how they have been used by the courts and how they have been interpreted by the courts. Okay. For that purpose, we have something called an obiter dicta and we have something called a ratio decidendi. A ratio decidendi is the crux of the case, and obiter dicta is the observations of the court. So how it works is that ratio of Supreme Court is binding. Okay, so a 5 judges ratio will be binding on a 3 judges bench. Naturally, how it goes linearly. Similarly, Supreme Court ratio will binding on the High Court because of Article 142 in Constitution says that the law of the Supreme Court is the law of the land. And then we have the High Court, where the High Court's 5 judges bench ratio will be binding on division bench, and then division judge bench ratio will be binding on a single judge bench. So this is how it basically works. Now, the obiter dicta is actually just the mere observation. So, for example, if we have a case, and in that particular case, let's say that it's a tort case, right? So you might have studied. Let me see. So there is a case where I believe there is this building that is constructed by a neighbor and the building gets collapsed. I don't know if you have studied that or not yet, but that's a very interesting case. You'll study it, I guess, later on. So, for example, in that particular case, let's say a building gets collapsed and the person who has incurred loss initiates a case of tort against the other person, right? So if the judge says in that case that, listen, this building got collapsed and because this particular elements of damages were fulfilled, so we have granted this remedy in favor of the victim who has incurred the damages. But if the judge says that even though this particular situation happened in this case, if, for example, if let's say not the building but a pet had gone loose out of a house and that pet had bitten the neighbor, then the owner of the pet would have been liable for damages. So that particular statement is obiter dicta. That's an observation. That's deviating from the actual factual matrix and then going into a completely whole new realm. And also, factual matrix and the facts of the memorial are the same thing. They are just synonyms of each other. Okay, now going back to this. So in this particular case, we have a cause of action. Then we try to find out what exactly what exactly were the arguments that we have to build on for the appeal, and what exactly were the cases used. Okay, so for example, in this particular case, it was said that holding the payer wherein the payment has been completely made by the other party. And then we have the double taxation claim that the other party has said that yeah, double taxation should not be done. And we also have the fact that there is a Hindustan Coca-Cola beverages thing that is already in action. And yeah, so, for example, yeah, they have given the double taxing over here. I think you can see it by I have highlighted it. And then they have also said that his retrospectivity stance by submitting it was always the case that in this taxpayer could not be penalized for not withholding tax. So we have CIT versus HCCV. So we have two arguments from the other side already, that they are going to go on for the double taxation and they are going to rely on that it was always the rule. And I hope I'm still presenting though. Am I?
No, you're not presenting. Someone else presented. That's why you got disconnected.
All right, cool. No problem. I can just start my presentation then. Let me know if it's visible. Okay.
Yes,
So
visible.
now that yeah, perfect, great. So now that we know what happens, we are going to go on to Indian Kanun, because we as a college don't have access to Manupatra, so we have to rely on Indian Kanun. So let's say we are going to take the case of Hindustan Coca-Cola Beverages Private Limited. All right, it's a very simple case. So I'm going to show you how research exactly is done on the basis of the cases. So now, if you type Hindustan Coca-Cola Beverages, naturally the exact case doesn't come. So what we do is pretty simple. We go on to one of the cases where Hindustan Coca-Cola Beverages have actually been cited. So naturally, you can see that this case has been cited over. This is a small case, right? So Indian Kanun is quite helpful because it gives you these two particular things. It gives you how many documents it has cited, the judgment has cited, and in how many documents and judgments this particular judgment has been cited, right? So from this particular judgment, you have to note down four things. One, who is the author of the judgment, okay, and what was the quorum. Second thing that you have to note down is when was this particular judgment delivered in 2007, and if it still remains relevant to us, it's something that we will find out. And then the third thing will be what is the ratio of the judgment, and then the fourth thing will be what is the obiter dicta of the judgment. Okay, the interesting thing is that there is no particular ratio of this judgment. Why? Because this judgment was merely an appeal, and this appeal was actually allowed because of a particular high court order and everything. How you know that there is no particular ratio of this judgment is for the simple reason being that it is the court just merely says that it is not necessary to go in detail as to whether the tribunal could have at all reopened the case, and over here we just have mere observations of the court then. So we don't have a ratio out of this judgment, we have mere obiter dicta out of this judgment. So for example,
Ma'am, how to tackle what is the ratio and how to find that how to find ratio from the judgment and obiter dicta from the judgment.
Okay, so let's do one simple thing, all right? I'll take your law faculty case, Matt, and we'll go through that, okay? Because you guys have studied it, so naturally, so I think we can go ahead with family law, right?
Yes.
Yes.
Yes. Okay, so is there any particular case that we should go through? Okay. So you guys don't have a preference? Huh?
Lily Thomas.
Dastane versus Dastane. Dastane wale.
Thomas versus Union of India.
Okay, I should not have asked that question then. Cool. Let's go through Dastane versus Dastane because that's a cruelty judgment.
Dastane case is good.
All right. So what page number is it? What's if you guys see the page number? Let me. Yeah, it's 88, right?
88.
Okay. So this is quite a lengthy judgment. Okay. So now, have you guys studied this case, Dasani versus Dasani?
Yes, ma'am.
Okay, perfect. So now what we will do is that, okay, so first thing, it's by V. Chandrachud, right? And it was a 1975 judgment. Two things that you have to note down first. Why 1975 matters is that you have to track down how the judgment has evolved. Okay, so from this particular judgment where cruelty was held as a cause for divorce, as a valid cause for divorce or not, to a judgment where even a mental cruelty case, even a suspicion of mental cruelty case has been held as a cause for divorce or not, we have evolved quite substantially, and we have to track down that evolution in judgments, and that really matters a lot. And that's why because why I'm telling you this is that other side, because when you're in a moot, when you're in a mooting competition, you are supposed to prepare from both the sides. So naturally you have an idea regarding what the other side is also going to use. And when you have that idea, you also know what are the substantial landmark cases that they're going to rely upon. Once you know those landmark cases, you can because the judges are going to ask you regarding that, right? So for example, if you're talking about a cruelty case, then the judges might really ask you that, what in Dastane, the Supreme Court held this. Do you want us to go against the Supreme Court's word then? Then you can always say that, no, Your Lordship, in Dasane versus Dasane, these were the facts. And ever since then, the jurisprudence has evolved from that particular ratio and has, gone over to this parameters now. So that really helps you to tackle those questions. And that knowledge really helps you tackle those questions. Why I ask you to note down the judge's name of also is because that really gives you a perspective regarding how the judges have used what was the acumen of that particular judge. I'm not saying that any judge has a lower acumen. That can never be the case because he's a judge. He or she is a judge. All I'm saying is that that really gives you an idea regarding how a particular judge treats a certain case. So, for example, if you see in Tukaram, the judge who gave the Tukaram decision, that particular judge had a certain mindset, and that certain mindset got reflected into the particular judgment, and that eventually seeps out into the judgment. Sometimes judges are also fallible people, and sometimes they have this certain subjective perceptions regarding the matter that get seeped into it. It goes through judicial application of mind for sure, but it still gets seeped into it. So naturally, it really helps you to know what, whether it was the Chief Justice who held that, and did the Chief Justice then waiver from his stand. So for example, in Keshavananda Bharati case, Y. Chandrachud had said that, state has all the power to amend whatever they want to. But in Minerva Mills, Justice Chandrachud then changed his stand and said, that the state has powers, but that power has limitations, and that limitations are then controlled by the basic structure doctrine. So naturally, you see that evolution. So that really gets important. Now, if you have studied the case, can someone just brief me someone just provide me a brief about the facts of the case then? Anyone? You said you have studied the case, so I'm really relying upon you for the facts now. All right. So no one. Let me just. There we go. Okay. So the facts of the case are quite evident from over here that this is just a matrimonial dispute where divorce has been filed on grounds of cruelty. That was the facts of the case. Why no one said is beyond me. Okay. So now the whole thing is that this particular person is a professor. And this woman has also comes from a very high-fi family and everything, and a cruelty case has been filed. And if you go through the letters, there are several letters, and there are lots of funny stuff and everything. But we are going to skip that because that's something for you to just rejoice in your own personal time. But yeah, let's go for the ratio of the judgment. Okay. Now, the ratio of the judgment in this particular case, I clearly remember, as I have carved out of it, was that that under a divorce, cruelty is a ground to file for divorce, and cruelty is a liable ground to have to be validated for a divorce. But if that cruelty has been condoned, then you can't, then your cause for action, which is for cruelty, will not stand because you have yourself said, I apologize to you. And how can that condone can be done? That's a whole nother thing. So when you see, for example, let's a pyramid. Okay, yeah. So okay. Oh, all right. Also, for the research purposes, please do note all these cases that are given to you in a particular case, because all these cases are the cases that have been held to be landmark cases because of which they have been cited in the judgment. So note them down, check what are these cases and where have they all been cited and everything, and then on the basis of that, you will have like a very substantial amount of research that you can do further on. So yeah, let's go with this. Okay, so this is the issue, right? Whether the has to be whether the conduct charged as cruelty is of such a character as to cause in mind of the petitioner a reasonable apprehension that it will be harmful or injurious for him to live with the respondent, right? So this is we are clear about the issue in this particular matter. Okay. Okay, yeah. So this is the obiter dicta. Okay, the court has gone into the intricacies of what an ideal couple should be, when the matter was not about the ideal couple, what the standards for ideal couple are. So this is an observation of the court. The court has to deal not with an ideal husband and an ideal wife, but with a particular man and woman before it. The ideal couple or a near ideal one will probably have no occasion to go to a matrimonial court, for even if they may not be able to drown their differences, their ideal attitudes may help them overlook or gloss over mutual faults and failures. This is one of the observations. This is one of the observations that are present in this case. Now, for the ratio. Okay. Okay. Oh yeah, and also, so I don't know if you guys are aware of an inversion test, but this will really help you out in your Moot research. So an inversion test basically is that when you extract a particular proposition out of a case, like when you omit a particular fact out of a case, then if the ratio of the case still remains the same, then that means that that particular fact was not essential to the judgment, to the ratio. Okay. And if you think that no, the inclusion of this particular fact changed the whole ratio of the judgment, then that particular fact is an extremely important fact. Okay. So for example, in this particular case, the fact that there was sexual intercourse between the husband and the wife, which ended as a condonation of the relations between the two, or that the letters were written with apologies to each other, was resulted in the condemnation between the two, proves that yes, there was an interaction happening between them. And if you extract that fact out of the case, then the whole ratio of the case gets changed. The whole ratio of the case then gets changed to the court conjecturing about what was the mental state and how the mental state was being adduced and all and everything, right? So it is a very extremely helpful thing, the inversion test, because whenever the judge in a particular moot competition throws something at you and says, but in this particular case, cruelty was not looked at as so harsh as you are saying, or ya fir uski bhi to galti thi, how are you defending that particular stance? Then you go by the legal propositions. Okay, you are not there to answer hypotheticals to the judges. You are there to provide them with a legal position of the law that is, and what the correct legal position of the law should be with respect to your case. That's the whole point of you being there as a counsel in front of the court. So the judges might try to deviate you from your particular stand with certain hypotheticals that for example, in this particular case of taxation, the judges, because I'm not going to mention about your case for freshers, because I really don't want to give you any points to argue. That is completely up to you and your skills and everything. So, for example, in the taxation case, the judge might say, but don't you think that as a taxpayer, he should have deducted a tax on the particular transaction and then paid the transaction forth? Then how can you say that he's not an assessee in default when he is not then he is not adhered to his tax obligations as an assessee? then we say that, your lordship, in this particular case also a similar situation happened and the court ruled this in this particular manner, and the ratio was this and the obiter dicta was this. So naturally we are just pleading that we are on the same grounds as of this case, and hence we are going by this. But for example, if in a and if for the department is said that, don't you think that you are doubly taxing this person, then we go by, no sir, double taxation is actually not prohibited under law. It is allowed under law if it is mandated by the legislation, right? So double taxation has certain intricacies and everything. So you need to know very well, you need to have a very well established knowledge regarding what exactly is a legal position about the fundamentals of law, right? So for example, for cruelty, you have to know exactly what elements of cruelty has to be fulfilled, what exactly qualifies as a cruelty, and what grounds a condemnation is provided, and what if the particular condemnation can be revoked or not, and how will a new ground for cruelty be created. So you have to be aware of all those elements, and only on the basis of those elements that you will be able to defend a certain hypothetical. So all I'm saying is that you should be clear about what a legal principle is, and then go henceforth from that particular point. Okay. Just moving forward. Also, I'm not sure if you know this, but our society is actually an open society. So you can very well just come across any moot and you can take part in it. So you won't really, so don't really feel bad even if you don't make it through the FIM. Okay. Now we come to the ratio of the case. Okay. So condemnation means forgiveness of the matrimonial offense and the restoration of offending spouse to the same. So this particular judgment defines what condemnation exactly is, right? What does it represent? So this will form the ratio of the case, because for the simple reason being is that if you take out the fact of those letters being sent to each other where sorry was said and sorry was accepted, this case gets changed monumentally. So naturally, this particular statement regarding what exactly is a condemnation is extremely important. More important is that to constitute condemnation, there must be therefore two things: forgiveness and restoration. Okay. Now this has been taken from the law and practice of divorce and matrimonial cases. But so you don't have to really state it, verbatim. You don't have to say it word by word. You can paraphrase it in however way you like. But the gist of the case will remain this: that there was forgiveness, and the forgiveness constitutes of two things. Forgiveness is condemnation constitutes of two things: forgiveness and restorations. Also, condemnation, if you look at the dictionary meaning, right? So, for example, like let's just look for the dictionary meaning, right? To accept that a behavior is offensive or wrong. So, when you look at the dictionary meaning, it kind of means something. It kind of means similar only. That like, okay, fine, I have forgiven you, I've accepted your behavior and all, right? But when you look at the legal jargon of it, that means completely different. That constitutes certain elements. The condemnation is an umbrella under which an action happens. So naturally, I would really ask you to go through the judgments, largely because going through the judgments will really help you in knowing exactly what the legal vocabulary is and help you build that legal vocabulary. Because when you go in front of a case, you don't say कि नहीं उसका करने का intention नहीं था, वो गलती से हो गया. You say that there was no mens rea or there was no actus reus, right? So you use those words as a lawyer, and that's the whole point of you being a lawyer and the other person being just a mere client, because you know those particular words, you know how those words are supposed to be used. So that knowledge of yours is used. Now we come to this. This is an obiter dicta once again, because we don't care what the likelihood of what the likening of condemnation is, but the court has still made a comparison between the two. It is not important per se, but this is just an observation of the court that it is not supposed to be a full presidential pardon under Article 72, that once granted wipes out the guilt beyond the possibility of revival. This is a mere obiter dicta. We already know that there are two elements of condemnation: forgiveness and restoration. So if those elements are fulfilled, condemnation is there. If those elements are not fulfilled, condemnation is not there. To observe this is a mere observation of the court. So this is a dicta of the court and nothing more than that. All right. I hope I'm clear regarding this. So a ratio is something basically which is based on the facts that you cannot replace. And an obiter dicta is basically something that the court observes regarding a certain things. So do I need to get into more detail of that, or like is it clear right now?
Ma'am, please once again, can you repeat what is ratio?
Okay, so ratio is actually the crux of the case. Ratio represents a rationale of the case, right? So have your teachers told you about what exactly is the difference between ratio and the obiter dicta? Okay,
Yes, ma'am, but it's a bit confusing sometimes.
okay, good. I can understand that. It gets really hard. You have to really get used to reading a lot of cases and then you are able to do it. Yeah, trust me, nobody gets it in the first semester, even in the first year. Ratio decidendi is a Latin
So
word.
we can cite both of these, means obiter dicta as well
Yes,
as
you
ratio.
can cite. You can cite because see, even an obiter dicta of a Supreme Court is binding on the courts, on the high courts at least. Okay, so it's just the obiter dicta of a high court that really is not binding on a high court. So that's the mere thing. But if you cite a Supreme Court case, then that is actually binding. Ratio decidendi is actually Latin for saying reason for deciding, right? So if you have a reason, so if you can detect out from the facts of the case what exactly was the fact which was the reason for deciding the case in this particular manner, you have the ratio of the case. That's all I'm saying. Okay. So in this particular instance, because the whole forgiveness and restoration, the whole condemnation aspect of it was the reason for deciding the case. Hence, this is the ratio of the case. It's as simple as that. Okay. And because we did not need to know if a condemnation is a presidential pardon or not, because see, this has already been decided that listen, you have to fulfill these two elements. Okay. This becomes a mere observation, obiter dicta, basically, right? So naturally, obiter dicta is also Latin for just saying by the way. You know how we talk in conversations regarding certain aspects. But by the way, this should have also been done in this thing. Similarly, the court says, by the way, condemnation. We're not saying that once given you can't take it back. You can take it back. It just depends upon certain circumstances. All right. So a simple example of obiter dicta and ratio is, so for example, if it's a case of an accident that happens, okay, let's say it's a tort case, there's an accident that happens, the court says that, listen, because you were careless and because you were negligent and because these are the elements of negligence, hence you are liable for providing the damages to the victim, okay? If the court says that that in this particular time the accused was in the car, and if the accused would have been on a scooter riding in a park and then there would have been an accident, then the situation would have been different. That is an obiter dicta, right? So the court is going on the whole by the way kind of a thing, whereas the reason for deciding is that you were in a car, you were drunk, you were negligent, you were careless, these elements of negligence are fulfilled, and hence you are liable for damages. I hope I'm clear now.
Got it.
Perfect. And even if you have not, just in case, when you read the judgments, you'll be able to detect them. So that's why I'm asking you to read the judgment so that you know exactly what factors were the determining, what facts were the determining factors. And just try to use a pencil, like take a red color pencil and take a yellow color pencil and have the yellow color pencil outline the facts of the case, and then have the red color pencil outline the important ratio of the case that was decided, the reason for the case for being decided in the way that it was. All right. So now we go on to this. In this, we'll go with, we have this. Okay, now I'll tell you how to do the research for the Dasani was Dasani. Okay, so we have cited by 329 documents and we have cites 14 documents. Okay, so it's quite simple exercise. It's just using a lot of other tidbits. So for example, this case uses only these particular sections and parts of the case, okay? And it has been cited by all these cases, okay? Now, first thing that you need to do whenever you're researching for a moot is go to the High Court and Supreme Court filter, then reduce this filter, because see, we had 3 to 9 cases that were cited. 340 cases, I don't know how many cases, but yeah. We have these many cases that are being cited for High Court and Supreme Court. We have 14 cases of the Supreme Court now citing the Dasani versus Dasani judgment, okay? Because you can't go through hundreds of judgments, right? So you need to line them down. So you have 14 cases to go through now. And even in those 14 cases, how you decide which one is important, which one is not. You see cited by 162, you go by this parameter. So you open up this judgment. And then you go through this judgment and then you see, okay, all these factors were cited in this particular case. So is this relevant to me or not? Sometimes you get a judgment with a head note, and the head note is basically nothing more but a summary of that particular judgment. So that also is very helpful. And even if you don't, and after you don't want to do this even, so then you can just choose it by the years. Okay. So how you choose the year thing is that, so you go to the 2002. Okay. Now let's say I want to check the cases from 2007. So I can very well check the cases from 2007 by merely changing the year. And then we have 2007 cases. It's as simple as that. So this is how you find the cases. And if you have to find, let's say, a particular section, then we have, sorry, not this, section 13, Hindu Marriage Act, 13(1) IB. All right. So once again, we'll go through the same exercise. Sometimes you get a case where it is in High Court. So naturally, you go by that particular High Court. So for example, I want to go by a High Court of Delhi because my case is in Delhi. Then you have Delhi High Court's judgments. And then you use the judgments which has a large number of cited by, because that means that that judgment is a landmark judgment and has been relied upon by a lot of other judges. Moreover, it will also help you know that whether a certain judgment has been overruled or not. Because if a judgment has been cited in your case mat and has not been quoted by the judges after a certain point of time, then that means that judgment has run its course and it's overruled now. Okay. In Manupatra, it's a very simple way of knowing whether judgment is overruled or not, because there's a small red flag that gets formed. Okay. So this is like one technique of getting to know the cases. And the second one is going on Google Scholar and then writing about India, and then just writing the keywords, okay? India, divorce, marriage, cruelty. So we have this now, okay? We have cruelty and companionship. We have divorce and separation in India. We have marriage as perceived panacea to mental illness and all that and everything, okay? Why I'm showing you this is because I really want to cover one important point, which is how to find research papers and references and citations and everything, okay? So in this particular case, we don't have wait, hold on. Can I find the DY? Okay, no, I can't. So we don't have the case.
Excuse
Yeah?
me, ma'am.
Yeah,
When
sure.
we get a proposition for any mode, so the first thing that we do is we research the sections that are mentioned, na? And
Yeah,
from the sections we'll get cases to read.
exactly, yeah.
Okay.
So if you don't get to find like a certain article, a certain research paper, see, the thing is that the research paper really gives you a background on that particular section, what has been happening, what is going on, because the books in a library are sometimes outdated. Like there'll be a decade-old book, and law gets changed in a decade quite substantially. So you can't rely upon whatever is a commentary over there. Okay, so you rely on books, you rely on research papers, and then you rely on whatever you can find. So, for example, if you can't find a certain case, a certain research paper that you think is very helpful, then you go to find a DOI of the case, of the paper. Okay, then you go to Sci-Hub. You put the DOI. I did not put it correctly, did I? Yeah. And then you can find the research paper over here. Okay. So this really works like a charm. So you can read the research paper now, you can save the research paper now, however way you like. Okay. So nothing is outside your bounds. Now, for example, if you see like an article on Hindu, okay. So for example, I'll see an article on Hindu. Wait. Yeah. So Hindu sometimes has a this, right? So they'll have like a like a paywall. So what you do is that you will go to outline, you'll paste the link of that article, and outline will give you the whole article after that. So exactly, you can go through this. So these are basically the ways of making yourself knowledgeable regarding the subject, regarding the fundamentals of law and what is the current status quo of the law. That's all that I'm trying to show you. And let's say that you want to find a book that you think that, you know what, like I think the book will be more than enough for me. Then you can just go to LibGen. And then from there, you can write, let's say, you can write Contract Act. think Mullah will show. Um, well, principles of Mohammedan law. We go with this then. Okay, so you can go and you can download this by clicking any of these mirror links that you want to. Okay, and the one thing that you have to note is that when was this book uploaded? Like, what is the edition of this book? So there's no edition given, so you can't rely on this particular book. But you can, for example, rely upon this book, which was published in 2014. So this is a 2014 edition. This is available in this language. This is publication by this particular person and all. Or yeah, there's a 1985 book on transfer of property act. So you can rely upon this if you want to go into that particular aspect and all. Okay, so you go with that. And sometimes when you have to find the bare acts of the case, don't find it on India Code, because that's really not a helpful site. They don't update the legislation over there. Okay, so go to like whenever you have to find something. So for example, we have to find Indian Penal Code legislative. Always go to legislative.gov.in, okay, because they always have like an updated version of it. And even if they don't have, they let you know exactly when the last time it was updated. So for example, if you search up Constitution of India and you click on legislative, then it will show you when it was amended the last time. So, and yeah, as on 9th December 2020. So it will show you like this, right? So you go with that thing. And sometimes when you have like financial cases and all, committee reports can also really help you in interpreting a law. So you go and you find out the committee reports and reports presented. You go in that, you search for a title, like for example, we search on demand for grants. That demand for grants basically means the financial amount that is given to a particular department. So demand for grants on agriculture and all that. So you can find out the reports. The reports really help you in interpreting a law. So whenever you think that you have run into a corner where you can't get out of, you can always rely upon. So see, this was a parliament, this was a legislative intention, and this is how the law has been enacted, and this is how the law should be interpreted. So that really helps you out. So I've taken you through like large parts of it, and this is how basically you go through the thing. So for now, I think we'll just take a short break at this particular point. And if you have any questions, you can ask right now and I'll answer those. And after that, I can tell you like the basic gist of how exactly to go about it. And so what I'll do is that I'll send you a memo. Okay, and I'll send that memo on where I'll just send a link. What I want you to do is that go through the memo for like 15 minutes, and then we'll resume the meet once again. After that, if you still have questions, that will be like a dummy memo that I'll be sending it to you. That memo won the best memorial at Kikiluthra. So that will be really helpful to you. Results.
Ma'am,
Okay. Yeah.
now is it compulsory to join Moot Court in first year?
No, it's not compulsory to join Moot Courts in first year.
So we can join in second year and second sem?
Yeah, you can join it anytime you want to, like any year you want to. And it's not even essential to join the Moot Court. If you want to take part in Moots, so I've sent you the link on the chat. And our judgments from High Courts also relevant in tracking the evolution. Yes, they are relevant. So if you read the Madras High Court judgment in taxation, because I'm sorry, I'm speaking so much about taxation, but I just love taxation. So if you read Madras High Court judgments in taxation, you will see the evolution of taxation that they have gone through. And if you know about arbitration, then in arbitration, there was this Vodafone case where Bombay High Court's judgment was way more sound in their reason than the Supreme Court. So the High Court judgments are also important from where the case is coming. So you should go through them, but there might not be time for you to go through them always. But I'm just saying that you should go through them. I can't take kuch bhi point. I'm so sorry, Sumit. I really can't take that because I really want you guys to frame your own arguments in your own manner. So yeah, so just go through the memo once, and we'll resume this after 15 minutes when you've gone through the memo and when you have your doubts and everything after that sorted out. If you have any more questions, and then we can take that up. All right. So I'll be leaving this meet. You can take the link, go through the memo, revise yourself, because I don't think that you will get a dummy memo. So that will really help. So I think we can resume it at 12:30. Will that be fine? Yeah.
How you just said that you have developed interest in taxation cases? How to determine that we have interest in criminology, in family laws, in arbitration?
Okay.
Because she
So
is
yes,
very interesting.
Naman, I understand that because you're in first year, so naturally there's like a lot of suspense regarding like what should I do, and all that. But and like where should I be? Am I a constitutional lawyer? Am I a criminal lawyer? Like who am I? There might be that existential crisis, but see the thing is how I discovered my passion for taxation and arbitration is that I joined Student Daily Law Review. Okay, Student Daily Law Review is actually a journal for the whole faculty of law of Delhi University. And while I was going through the editorial board process, I was given a lot of manuscripts. I was given a lot of articles. I had to read through the articles and I had to research on those articles, like what were they saying? Are they relevant? Is the author making sense or not, and everything. So I researched on all those articles, and through that research, I came across certain legal arguments that I really loved. Okay, so how I fell in love with arbitration is that I read about a case, White Case Industries, where India had lost arbitration. Okay, and in like a typical attitude, India was like, you know what, we are going to start afresh. Like पीछे से सबका पोछा मार दो. We are going to start with a new treaty now with every other country. So that I found really fascinating, how that whole event, how that whole chain of events happened, and I really loved reading the judgments, and I really loved reading judgments after that also. And in taxation, I actually saw a couple of lectures by Arvind Datta. He's a senior advocate in Madras High Court, and I was really inspired by what he said regarding taxation and his passion for taxation. So I read a couple of articles on taxation. I started reading about income tax and how direct and indirect tax works and what are the intricacies of that. And then I took part in a moot. And then while researching for the moot, I realized that I really, really, really love taxation, and I really love the whole ridiculousness of it and sometimes the brilliance of it. So that made me fall in love. Like for example, I'll just tell you a case in taxation. What happened is there was this particular hospital, and this hospital. So there's this. Okay, not okay. Let me just tell you a case of Uttarakhand. This really happened on the judgment has come out on 17 February 2021, so you can check out the judgment. The judgment is about an Alaknanda power infrastructure and everything. So this was a power generating company. It was in an agreement with the government that we will give you 12% of our electricity as free as like a taxation, and then you will not charge us for using water and or using any other thing and everything. And the government was like, fine, cool, let's go ahead with this. And what happened in that particular case is that the government then introduced a water tax for non-commercial purposes. And when they introduced the water tax, the Alaknanda company said that, listen, we had an agreement that we will give you 12% electricity, 12% electricity. Why not, doing the whole taxation? Why are you making us go to the water tax also? So then the government said that, listen, we have the power to tax you, okay, because we can tax land revenue. Okay, and what is land revenue? So what exactly is land? Land is anything that is we can have any revenue which is above the land and below the land. And what is a river? And you are using Alaknanda water, right? So what is Alaknanda river? Alaknanda river is on the land, right? मतलब नीचे जमीन तो कहीं ना कहीं होगी ना, तो एक्चुअली में हमारा टैक्स उस जमीन के ऊपर है और पानी के ऊपर नहीं है, तो इसीलिए हमारे पास कॉम्पिटेंस है, लेजिस्लेटिव कॉम्पिटेंस. सो यू सी द ridiculousness of this particular argument. But yeah, so that really inspired me to go into taxation and really explore the field of taxation. You will get to know about what is your field and what do you love by really researching on it, by going through a lot of judgments and finding out that, no, I find this interesting, I'll find out more about this, I'll read more about this. So read a bit more, and you'll get to know. Anyway, we will resume at 12:30 if that is fine with you guys, and you can just go through the. I'll take the questions again.
Thank you.
I hope that's fine. Right? So anyone who wants to discuss further more about them.
Actually, I have a doubt.
Yeah, go ahead.
Can you just tell us how to go about deciding the jurisdiction of the case?
Oh, so jurisdiction is a very simple thing. What you have to do is that you have to look at a particular section, and if you see if that section is applicable to you or not, if the code is competent or not, then you can go ahead with it. Sometimes jurisdiction is also an issue, so that particular issue gets argued upon. So, for example, let's say that there was a person A, and the person A was had gone through an accident in Haryana. but person B who was responsible for the accident lived in Delhi, right? So where do you find for the jurisdiction? That really depends upon your cause of action then, right? Where did the injury happen? And where and does the court in that particular jurisdiction is the competent court to adjudicate over it? So that really helps you. Sometimes jurisdiction is just a mere statement of jurisdiction and nothing more than that. So you just have to write down a section. Like for example, in taxation, you have section 260A of the Income Tax Act, which is regarding appeal of the orders from tribunal. So you file a jurisdiction under that, and a high court has the power to go ahead with it. So I think the major thing that you have to do with that is just get a book, okay? And in that book, you go through the section, which is like, for example, for CPC, you can take Takwani or Takwani, I don't know. I don't really know how to spell that. So you go through that book and then you find out about the ingredients of the section that are required for the jurisdiction stuff, and then you file under it. Jurisdiction is not really that of a pertinent matter because sometimes it's just given to you in a memo saying that, you know what, you are at a high court of Madras and that has been decided. So you go ahead with that. So that's it.
Okay. Thank you.
No problem. I'll take a final detail of these questions at 12:30 if that is completely all right with you. I'm sorry, I really have to rush out for something. So 12:30 we'll reconvene. If anyone is further interested in it, I'll take because after 12:30 is just a Q&A sessions. So I'll take all your questions after 12:30. Okay. All right. We'll reconvene at 12:30. Yeah.
मैम क्या आपने हम लोग को जो प्रोपोजिशन मिला है जिस
Yeah.
मूट कोर्ट उसके क्वेश्चंस को आपने देखे हैं मैम? I'm just asking.
Wait, hold on. Just hold on. Hello?
Yes, ma'am. Okay.
Yeah. Hello, can you hear me?
Yes, ma'am.
Yeah.
मैम
Yeah.
मैम पूछना ये था कि वो जो क्वेश्चन था उसमें मैम हस्बैंड के फादर मदर पे चार्जशीट लगाया गया है, तो मैम इस पोजीशन में आता है उसमें हस्बैंड पर भी ये बोला जाता है कि चार्ज लगेगा कि नहीं लगेगा, हालांकि हस्बैंड के फादर मदर का नेम नहीं दिया हुआ है, तो मैम इस केस में क्या किया जाए?
See, those are the things that you have to decide. Okay, like I can't give you legal advice right now. This is not fair. Come on. That is your legal research. That is completely upon you. And what do you find about those cases? Because see, there are some people who have taken one side, and then there are some people who might have taken the other side, right? So you have to find out regarding that. So just talk to your friends regarding what research, like share your research, right? Like that is completely understandable that you are living at a distant place. So naturally you can't go into the depth of research, but share your research, like talk to each other, discuss about what you think, what should be the correct law, because it's only through discussion and deliberation that you can finally decide upon like the finer intricacies of the legal provisions. So just go through that. I'm genuinely not going to advise you about the FIM thing because I really don't think that's fair. But if you just talk to your friends, I believe that will be the correct way to go about it. And also, so anyway, I'll reconvene at 12:30 and I'll have like an important announcement at that time to make. So if anyone is further interested into knowing this, they can join in at 12:30 and I'll take all your questions at that time. So if you have a legal question even related to FIM, then because I have to rush, so I'll take even that question at 12:30 then, even for FIM. All right.
Yes,
Good.
ma'am.
Great. Thank you. All right. I'll come back at 12:30 now. Bye.
Okay.